Nagaland government, after successfully passing the new municipal bill with 33% reservation for women, told the Supreme Court on Friday that the process of the election will be completed by 31st April 2024. Appearing before a bench led by Justice Sanjay Kishan Gaul, the state government also recorded an undertaking that the required rules under the 2023 Nagaland municipal bill will be framed within a month. Appreciating the move by the state government, the bench, which also comprised Justices Sutanshu Dhulia and Asanuddin Amanullah, took on record the statements of State's Advocate General K.N. Balagopal, fixed the next hearing of the matter on December 11, saying the northeastern state is expected to frame the rules by the next date. The top court's comment referred to the flip-flop by the Nagaland government while responding to a petition filed by the People's Union for Civil Liberties in the Supreme Court in 2016. It was while hearing this matter, the top court passed a string of orders directing the state to give effect to the constitutional mandate on reserving seats for women in urban local bodies. In 2001, the Nagaland Municipal Act was passed, and in 2006, reservation for women in urban local bodies was introduced. But in September 2012, the Nagaland Assembly passed a resolution not to give effect to Part 9A. Though the Assembly later withdrew the resolution in November 2016, the same was not implemented due to opposition by state tribal leaders who even indulged in large-scale violence to block the cause of women reservation. In March this year, the state government repealed the 2001 Act. The state took the defense under Article 371A, a provision in the Constitution which relates to special provisions for Nagaland. This provision seeks to protect the Naga customary law and procedure along with their social, religious and other rights, making a resolution by the State Assembly mandatory for implementing any provision of Constitution that touches on any of the subjects under Article 371A. The state further canvassed an argument that the implementation of Part 9A will lead to an anomalous situation as women in urban local bodies will get reservation while those in villages governed by Panchayati Raj institutions will be denied the benefit. This was because the operation of Panchayats under Part 9 of the Constitution is specifically excluded for Nagaland by Article 243M of the Constitution. But the Apex Court remained firm in its order since February 2022 that an important issue of gender equality was getting postponed, as the state government assured the court that they will give effect to the 2001 Act for reserving seats for women. In March, the State Election Commission notified elections to municipal bodies on the basis of the 2001 Act, but the government repealed the Act in the same month, leading to cancellation of the municipal elections proposed to be held in April. Incensed, on April 17, the court issued notices to Nagaland Chief Minister Nipirio, State Chief Secretary and tribal leaders in the state for repealing the 2001 Act and violating the undertaking given to the court for rolling out 33% reservation for women in local bodies. On July 25, the court gave a final opportunity for the state to act by September 26, warning that it would step in if the matter stood unresolved. Following this diktat, the state introduced the bill in the Assembly on September 10, which was finally cleared on Thursday. After the passage of the bill, CM Rio said that the new law, which the state is going to have, is not the end but only a beginning, and that time has come for women to participate and perform in the administration of the urban local bodies.